Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. I'm here with Ann Lipton, law professor at Tulane in New Orleans, who teaches and researches securities and business law, and she holds up the very important legal end of our podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Or I try to. I don't do as well on the financial side as you do on the legal side, but anyway. So you're doing great, Ann, it sounds like. You're done with your travel, right?
For now.
And now you just have to administer and grade exams, right?
I have to administer and grade exams, and very quickly so that the graduating students can get their grades before they leave.
Can go forth into the world and administer justice.
Yes.
All right. Well, this week we can talk about a couple of things. There's some more litigation, a lawsuit. This time involving Target and Pride marketing. Yep. So it's a cousin of some of these other kind of ESG or DEI woke related
exactly.
matters that have kind of wormed their way into securities law. And this one asserts that Pride marketing, putting Pride goods in a store constitutes securities fraud.
Yeah, exactly.
I can't wait.
And we'll also talk about what it means and doesn't mean to solicit proxies, just as proxy season starts to take off.
Yes, that should be kind of fun. So let's plunge into a discussion of Target, our favorite kind of sometimes hip retailer. And they encountered a lawsuit over basically the Pride merchandise. We don't have to talk about the Pride merchandise. Yeah. That's well known about what it was doing. But describe the lawsuit. What was going on?
Yeah. So just quickly, in 2023, I guess, Target marketed this Pride and trans-friendly merchandise, and it was all big news because there was backlash, there was boycotts. I think some consumers actually physically attacked Target workers.
Yeah, it was sort of a precursor to bombing Tesla dealerships.
It was pretty ugly. And
Right.
Target's stock price fell. And so after that, 5 shareholders filed a federal securities fraud lawsuit in Florida against Target. And the one thing I want to point out, because this is going to be important to our story, is this wasn't a class action. These were 5 shareholders who were suing only on their own behalf, and they wanted personal damages for their own losses, but what they also wanted was injunctive relief. They wanted new disclosures about their ESG risks and oversight, a new board election because they said the fraud impacted a proxy vote. That's what they were asking for. And that's unusual because most securities cases are filed as class actions seeking damages on behalf of
they're usually about money.
Yeah, they're usually about money, but this was not about money. And that really, I think, tells you something about the goals here, that it wasn't economic. I mean, I think this was a lawsuit that wanted to make a point about marketing Pride merchandise. In fact, One of the plaintiffs was Inspire Advisors, which is an investment firm that explicitly takes a biblical approach to investing. Actually, a related entity, Inspire Investing, was sanctioned by the SEC for lying about how much they actually consider the Bible, but that's a whole different thing. Anyway,
was that the case where they were sanctioned or whatever for misrepresenting what kind of investing they do?
Yeah. Like they said, we will carefully screen for biblical something.
Right.
And they didn't carefully screen.
I mean, a whole bunch of ESG funds encountered that.
Yeah.
But saying that they weren't ESG enough.
Yeah. And
something.
Inspire Investing was one of 2 actually that did this from a religious angle and got in trouble.
And they were a plaintiff, so they were one of these 5 plaintiffs. Does it matter that it was? Is it important that it was in Florida?
Well, I don't think so. But Florida will play a role in our story. So
okay, great.
So anyway,
why wasn't it filed as a class action?
Oh well, I think because at the time, I think they were after these particular injunctive relief things.
The non-monetary damages.
Yeah, exactly. And they were even represented by America First Legal, which is a conservative activist law firm. They file a lot of anti-DEI cases, that kind of thing. So this was really kind of a political lawsuit. And the actual legal claim, though, was that Target warned shareholders about potential controversy surrounding its ESG efforts, but left out that, in fact, the board was not monitoring for the risk of backlash. It was only monitoring the risks of not being liberal enough and not the risks of being too liberal. And the plaintiffs argued that these risk warnings, which only warned about potential controversy for ESG efforts, but not the risk of backlash, that these risk warnings defrauded them as purchasers of Target stock and also defrauded them as voters in Target shareholder elections because the false statements in the proxy materials caused the board members to be reelected. I mean, the claim was that shareholders would never have reelected the board if they'd known the board wasn't in fact monitoring
was
for the risk.
neglecting the possibility of backlash
of
to the
conservative backlash.
And that was based on, it sounds like, disclosures probably in 10K kind of
well,
risks
actually,
and
it was
uncertainties.
in the proxy materials.
In the proxy. Okay,
exactly.
Wow.
Yeah.
All right, keep going.
So I gotta just say that it's a ludicrous claim. Okay, it's a ludicrous.
This sounds kind of wild. I'm
it's
sorry.
a ludicrous complaint because and to explain why, you have to have a little bit of the history of securities litigation. So back in 1995. Congress became very concerned that securities fraud lawsuits were too easy to bring, that shareholders were filing nuisance lawsuits to blackmail companies into a quick settlement. And so Congress passed a law known as the Private Securities Litigation Reform Act, or the PSLRA, exactly, that made it much harder to bring securities lawsuits, mainly because you have to include a lot of detail in the complaint that establishes the basis for alleging fraud. You have to allege particular details about which statements were false, why you think they were false. You have to show that it's more likely than not merely plausible, but actually more likely than not that any insiders acted with intent. And this Target complaint, I mean,
a lot of high thresholds.
Yeah, it was just lacking in every respect. I mean, first of all, the only false statements were the ones where Target said it could receive negative publicity over its stakeholder outreach. It said stakeholder expectations are not uniform and they're constantly evolving, and therefore failure or perceived failure to achieve goals could result in harm to the company. That's not a false statement. That's an entirely true statement.
And that's a quote from the disclosure.
I am paraphrasing, but that's functional. Like that's basically what they said. So this is not I mean, the actual statement is like a paragraph long, but really that's what it said, and it's not false. It's entirely true. And the only evidence the plaintiffs had that the company did not actually monitor for conservative backlash was that back in 2016, Target had opposed North Carolina's bathroom bill, their anti-trans bathroom bill, and that resulted in some protests. And at one point, one of the Target board members said they hadn't monitored those risks carefully enough. Oh. That tells you nothing about what the company was doing 7 years later.
Or nothing, you're right, nothing about what, I mean, this conduct was in 2020.
This is in 2023, as opposed to the 2016 bathroom bill. So, so nonetheless, really shockingly, the district court in Florida refused to dismiss the complaint.
Oh, I was going to ask what happened. So they went to appeal for summary judgment or something.
No, not summary judgment. This is just motion to dismiss, because that's where a lot of this litigation happens. Because the pleading standards are so high in securities cases, almost all the action is actually at the motion to dismiss the complaint. Did you meet the pleading standards? And shockingly, the district court refused to dismiss. I mean, you have to understand, normally securities fraud complaints might have dozens of confidential witnesses who report on problems with the company. You'll see courts still dismiss complaints because those witnesses can't attest to the precise information that was communicated directly to the board, and therefore you can't infer that the board acted with intent. But in this case, the court was completely willing to infer that because Target had experienced this backlash in 2016, it must not have monitored the risks. In a different state. It must not have monitored the current risks of going too far with liberal causes 7 years later. I mean, it was so obvious to the court that if you had a backlash in 2016, you can't possibly have made an informed choice to engage in pride marketing in 2023. And certainly the court didn't even ask if the company might make a strategic decision to cater to a customer base in hopes of a long-term payoff.
Okay. Oh, wow. So the current status is they're probably taking more discovery, and this is kind of steaming along.
No, that's not where we are. It actually is more complicated than that.
Oh, okay, keep going then.
I mean, so we talked about a case like this. We had a podcast on the American Airlines case.
So I was going to say this seems kind of remotely related to that one, but that was about stakeholders or retirees.
It was retirees
suing American Airlines including over the ESG positioning of the funds that they were allowed to invest in.
But it's a lot like that case, because there it was a Texas federal court that held American Airlines breached its fiduciary duties to participants in its 401k plan, because the plan included BlackRock funds at a time when BlackRock was voting in favor of climate change resolutions. And to that court, it was the same idea. It was obvious, without any further analysis, that if you vote for climate change resolutions, you're necessarily sacrificing shareholder value. Same idea here. There was no possibility that Target might have made a considered decision to cater to a liberal market. If Target chose to cater to liberal customers, the only possible inference is that the decision was not considered and that Target did not take risks into account. The court actually compared this case to one involving click fraud, where an internet company sold advertisements and the advertisement had to pay every time someone clicked on an ad.
So in a ruling, they did this comparison.
Well,
okay, wow.
that's what So this click fraud case, you have to understand. So this click fraud case, an internet company sold advertisements. The idea is that the advertiser pays whenever anyone clicks on the ad. So of course, one thing that way to defraud the advertiser essentially is to generate a lot of false clicks.
It's a lie about how many clicks you have.
Exactly. And in that case, that happened several years ago, the company lied about the steps it was taking to monitor click fraud. It said it was watching out for it, but in fact, it was letting the click fraud happen. So here in Target, the court compared to the click fraud case and said it's the exact same thing. Target warned about the general risks of ESG, but never warned about the specific risk of conservative backlash. But it's not the same thing. These are not the same thing.
No, this doesn't sound even close.
Yeah, you can't legitimately decide to defraud your advertisers, but you can totally legitimately decide to engage in a public marketing scheme to cater to a particular demographic. Except apparently, according to this one court in Florida, you can't. Choosing to allow click fraud and choosing to market Pride merchandise are exactly the same thing. Yes.
Or equivalent. Yeah, that doesn't sound right.
No.
So the court refused to dismiss, and then what? Well, I started asking this, but what happened after that?
Okay, so it gets even more bizarre. This is just wild. The parties agree to go to mediation. And then, for the first time, the plaintiffs tried to amend their complaint to make it a class action because it hadn't been a class action before, except they couldn't, because the PSLRA, the same statute that imposes these heightened pleading requirements, it has some really specific procedures for class actions. See, one of the concerns that motivated the PSLRA was that securities fraud was all lawyer-driven litigation. You'd have a client with maybe one share of stock, and they wouldn't pay attention to what the lawyers were doing.
So you're shopping, so you get this theory and you shop for a shareholder.
Right, exactly. And then the lawyers will rack up expenses and they'll settle with no benefit to the class. So Congress changed the rules. Today, if you file a class action in a securities case, you have to also issue a press release and tell people that you just filed a class action. And at that point, other investors have the option to intervene and compete for the role of lead plaintiff. And the court will look to all of these different investors who are competing for the lead plaintiff spot, and they'll choose the one who will actually take on this role. And the lead plaintiff role is really critical because the lead plaintiff is the one who runs the litigation on behalf of the entire class. They hire the attorneys, they file a new complaint that covers all the allegations, they handle the briefing, they handle discovery, and critically, it's their attorneys that get the fees. So in securities class actions, everything is about the lead plaintiff, and in particular, who the lead plaintiff selects as their counsel, because they make all the strategic decisions. So under the PSLRA, usually the lead plaintiff is the investor who lost the most money, who has the most dollars at stake.
Oh, who's the most at stake.
Exactly. For the obvious reason that if you have the most money at stake, you're the one who's going to pick an attorney wisely.
Or try hardest to,
Exactly.
To prevail.
Exactly. But these plaintiffs in Target, they skipped all those steps, which meant that they couldn't just convert to a class action. So now we had a new twist. The same attorneys who represented these 5 plaintiffs, they found a new plaintiff. And who did they find?
I am dying to know.
The State Board of Administration of Florida.
The SBA?
Florida's retirement
is a
fund.
plaintiff?
Florida's retirement fund.
I mean, I've worked with them. They're like they're about as I mean, I haven't talked to them in a long time, but they're a very progressive. They're huge. And they're a very progressive. They're a leading member of the CII.
Well,
they're really good people.
I'm not sure that I would call them progressive today. They're being represented by America First Legal. And I want to be clear, state pension funds bring securities lawsuits all the time. They frequently serve as lead plaintiff. But Florida's fund, represented by America First Legal, also the Florida Attorney General is also representing them in this complaint against Target.
Like as co-counsel kind of thing?
Or? Exactly. So I don't think that they're still as progressive.
So this is interesting. So this kind of started, as we were saying, as sort of a ideologically motivated case with these 5 shareholder plaintiffs, one of whom was that other kind of funky
Inspire
fund.
Investing,
Inspire, right. And it kind of evolved to now include the state. The state of Florida, which is, of course, everything kind of runs up to the governor.
Exactly.
So he's got to know what's going on with this.
I think this is about Ron DeSantis. I totally think this is about Ron DeSantis. So he's been very active in targeting companies and investment funds for what he calls woke investing. He already went after Disney for opposing Don't Say K.
Oh, sure.
He accused Bud Light of violating its fiduciary duties to shareholders when they were working with that trans influencer. And that was all at the same time as this Target stuff was happening. So Florida suddenly getting involved, it looks to me like it's another instance of DeSantis putting the screws to a company that he views as engaging in woke business practices. But we're not done. Because remember, under the PSLRA, anyone can compete for the lead plaintiff spot. So the State Board of Administration of Florida came in, but then another plaintiff came in. And who is this other plaintiff? The Ohio retirement system. And that has its own history. Because as I understand this, apparently the Ohio retirement system, their pension fund, didn't want to be involved precisely because they viewed this as a political stunt.
They were probably approached at some point to do this and originally probably declined.
Well, they apparently did want to decline. I'm not sure how they were approached, but apparently they did want to not get involved because they viewed it as too political and they were maybe they were even sympathetic to Target. But then the Ohio Attorney General insisted that Ohioans needed to be protected from woke governance or whatever. Now the Ohio system decides to compete to be lead plaintiff, except they aren't being represented by the Ohio Attorney General. They're represented by Grant and Eisenhofer. Grant and Eisenhofer.
The Delaware firm.
They're a major Delaware securities fraud law firm. They're a very mainstream plaintiff class action firm. They're very experienced at these kinds of suits. So my guess here, honestly, is that Grant and Eisenhofer, they know that this suit is ridiculous and they had no real basis and they never would have filed it originally. But once it survived a motion to dismiss, now there was an opportunity to cash in. So now you have these 2 competing plaintiffs for the lead spot, the Florida system and the Ohio retirement system. And they're arguing about who had the bigger losses because that's the big question under the PSLRA.
Right, that's the factor, the predominant factor for determining.
It's supposed to be the main factor for determining, and they have like different arguments about how you calculate losses, which whatever. But they're also arguing about which one of them is taking an ideological approach to the case.
Oh, interesting. So in addition to just the monetary factor about who got damaged more, they're also saying no, Florida, you're You're the one who's pushing a political agenda here, and we're just in here for the money. And Florida's saying, no. We have 5 of us and a big state fund, and we're in it for the money, and you kind of jumped on the bandwagon later.
No. They're both saying that the other side is ideal. So so Grant and Eisenhofer is arguing that Florida is approaching this ideologically, that they're using the same attorneys as in the original action, and that Florida in its papers has characterized this as a suit about stakeholders versus shareholders. And Grant and Eisenhofer is arguing this is just a routine securities fraud case. It shouldn't be approached as a matter of ideology. Meanwhile, Florida is arguing that Ohio is the one that's ideological because
Yes.
they're big ESG people. Because not only did Ohio not want to file this case originally, but Grant and Eisenhower as a firm has adopted all kinds of ESG policies. So Florida
or
even
woke or DEI.
yeah, exactly.
Kind of
They
stuff.
have like
Yeah,
on their
right.
website, we care about ESG, whatever. Florida even included data, and this data is from a conservative organization devoted to like exposing woke business or whatever.
Right.
So Florida included this data that purports to show that the Ohio retirement system votes in favor of ESG initiatives more often than the
More than the Florida
right,
Florida fund.
which really just shows this assumption here, which is just taken as baseline, is that there's no universe in which catering to liberal preferences is wealth maximizing.
It's gonna work,
Conservative
yeah, right.
positions are the only way to make money. Anything else is special interests. And I want to unpack that for a moment because it's a really specific claim. The underlying assumption is conservatives are, in fact, the majority of shoppers, they're the majority of consumers, and they represent the mainstream of America. And therefore, if you cater to liberal preferences, you're not
You'll
catering.
lose money.
You'll lose
Right.
money. You're not catering to mainstream America. You're sacrificing customers. So you must be doing it on ideological grounds, not out of a business motive. Now, you can see why conservative politicians want to argue that. Of course,
Right.
conservatives...
They want to believe that, but
Exactly.
I mean,
They want to believe that they are just representing the mainstream and everyone else is fringe. But I don't know that that's true.
no, this is a big country. There's lots of diverse tastes and consumer preferences.
Exactly. I mean, for example, like one little data point is right now we know that a lot of businesses are coming under pressure from Trump to like get rid of DEI or whatever, and Target agreed
right.
to scale back its diversity initiative.
Sure.
And that inspired a boycott. And its foot traffic has been down.
And Target sure. I've been an on and off investor in
Yeah,
Target.
exactly.
And,
So you
and
must have
Target
seen
took
it.
a hit.
Yeah, exactly.
On this.
Exactly.
Yeah.
Meanwhile, Costco refused to scale back its diversity initiatives, and its foot traffic has increased.
It's right, and its share price has done
Exactly,
well for a long
exactly.
time.
So I
Right.
don't know that there's an exact cause and effect here, but it certainly makes clear that being politically conservative does not always mean forever you're going to increase your sales.
The thing I want to come back to is the fact that this case is, I think, and when there's no way to predict, is kind of a loser. Right?
Yeah. Well, I mean, it was before this judge, I don't know, but like it should have been like under the law, as I understood it, it
Right.
absolutely should have been. So, but all of this is just this bizarre fight to be having in the context of a securities fraud case. We went from a
Right.
pretty explicitly ideological securities fraud claim to now a battle over whose ideology is appropriate to manage the case going forward. And
Right.
the bigger picture here is it's not supposed to be a free speech case, but that's what it's looking like.
That's what it's becoming.
Exactly.
Yeah, right.
When this becomes Ron DeSantis and America First Legal using a Florida state entity to argue that Target violated the law by carrying Pride merchandise, and
Right.
Grant
Around the
Eisenhower,
country. This isn't just
and Grant Eisenhower can't lead the case because they're too supportive of diversity. That looks like a governmental entity punishing private entities for their expression.
I think you
Right?
may have a good point.
And my
here.
question is, like, how and when will we start to recognize this as a First Amendment problem, that liberal initiatives are seen as inherently suspect, where conservative initiatives are presumed to be wealth maximizing and legally compliant?
I don't know.
Anyway, but
Wow.
that is where we are. Like, so now the case,
I'm just marveling at these firms, especially Grant
Yeah.
Eisenhower, who's aggressive. They make their money off this kind of stuff. Dealing with this case, which who knows where it's going to go, but it doesn't seem. I mean, it's Target. Target's a great defendant here.
Yeah, I mean,
in terms of getting money, but
there's no question that Grant Eisenhower knows the weaknesses in the case. I think as I said, I think they came in because they saw it survived a motion to dismiss, and after that, they
Right.
knew that probably at the very least settlements on the table. So.
they'll get something out of it.
So, but this is where we are. Nothing more happens until they select the lead plaintiff, and we go from there.
Right. Oh, so this is going to be a while before there's progress here. So, all right. Well, we'll have to stay tuned. We'll have to come back to this one, I think. Wow. That is pretty fascinating. All right. Let's take a quick break and come back and talk a little bit about what it means to solicit proxies here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin. So, Mike, let's take a look at what it means to solicit proxies.
Soliciting proxies. Go ahead.
Proxies. So what is the legal technical definition, and why do activists care?
I want to just mention I've been very eager to go over this with you.
Okay.
I've been wanting to talk to like my favorite legal scholar about some of the nuance here and some of the technical parts, because I think it kind of matters in this proxy season, because it influences kind of what activists can and can't do at various points during an activist project, and who they can talk to and how they can talk to other shareholders and what you can put in writing. And so there's some, and I've read it over, and I don't exactly know what I'm reading, but I try. Some of the statute, and it's in the Securities Act or whatever it's called. And part of this was motivated also by, I think we've talked about it, the book Dear Chairman. You know, Jeff Graham was a guest on the podcast while you were out at some point. And if you haven't looked at it, Ann, you gotta pick this up, because he tells these stories about, decades ago, about, shareholders in like railroads soliciting proxies. But literally, this is when people had to travel to shareholder meetings. Right. And they couldn't, and if you couldn't, some other shareholder would be knocking on your door, literally saying, "Hey, give me your proxy, appoint me, pick me." And it was a lot of fraud going on. There was a lot of really underhanded stuff, representations and so forth.
That was part of what inspired the Exchange Act in the first place, like the
exactly.
rules in the first place. Yeah.
So he tells a couple of great stories, going back in archival research about, the act of proxy soliciting when it was, around, in the 20s and 30s. And, fast forward to today, there's a lot that's evolved, but still the legal underpinnings of this and how it influences, what I can and can't talk about with other shareholders is always been kind of interesting to me. So there is, a technical meaning. There's Rule 14A, which is very familiar to any lawyer who practices in the activism space. Has a very technical, almost ornate description or definition. It's 240.14A1L. Okay. Solicit and solicitation include requests for a proxy, whether or not accompanied by a form of proxy, a request to exclude or not excluded to revoke a proxy, furnishing of a form of proxy or other communication to security holders under circumstances reasonably calculated to result in the procurement, withholding, or revocation proxy. So it's not merely the asking for a vote.
It's not merely. It's nothing as obvious. It's also any kind of conduct or that could you would expect will have someone.
Someone appointing you. Well, but it's not merely appointing you proxy, which is the act that we're concerned about, because then you show up at the meeting with a stack of letters that say I've appointed you proxy. But there's a lot of kind of gray area here. It's like vote for me. Right. And it could any kind of, document that you send out that says, here's our candidates and we'd like you to consider them, or even like oral communication, like stuff over the phone or whatever. So there's a lot of communication that this is designed to kind of cover.
Right. All that comes under the definition of soliciting. Yeah,
exactly. And so I trying to parse that, not in huge depth here. There's scholars and treatises on that.
Right. And the reason it matters is because if you are soliciting, then you are within the ambit of SEC regulation, and if you are not soliciting, then you are not within the ambit of SEC regulation. So it's the distinction is really important.
Right. And the reason the specific reason becomes important is because once you're deemed to be soliciting under the scope of the law here, there's a very long, arcane, fairly complicated list of things you have to do. Filings you have to make, 14A preliminary and definitive, and huge amounts of disclosure about yourself and your nominees and so forth. And if you're not soliciting, you don't got to file all that.
Right,
you can just sort of have what I would consider, and other activists would consider, a constructive, informed conversations with other shareholders about what's going on at a company. Okay, but we're not verging over. We're not kind of going over toward the
Right.
Vote for
So,
me.
your
Send in my
communication-
proxy card.
Your communications
situation.
become regulated if you are soliciting. And
Right.
and the default, so the default is once you're soliciting that you have to file all kinds of documents and disclosures unless you can find an exception. But yeah.
Right, and there's more, and activists that have done proxy contests are familiar with this, but others, it's not merely the filing of the proxy statement, but there's all these supplemental or additional that you have to. That's why we see if you're filing a proxy contest, sometimes every day, twice a day. Go look at what's being filed in the Phillips Elliott proxy contest right now. There's, anytime Elliott, sends out a tweet or puts something on social media or whatever, they're filing another disclosure, and that's because that's the act of soliciting has been committed. They've committed the act of soliciting, and so they need to kind of keep complying with the law. And there's all these disclaimers. Okay, so I want to make a couple points about this. In addition to saying okay, we want to figure out when we have to and don't have to comply with all these disclosures. That first, I want to make a distinction between soliciting a proxy and succeeding in collecting, or succeeding in gaining a proxy. And I think that's a very important distinction. Okay, because that has to do with some other aspects of compliance. So many companies in their bylaws or their constituting documents have this requirement that you solicit a certain percentage of proxies. Frequently, it's like half of the voting power representing half of the outstanding shares, and that's just part of bylaws frequently. However, the soliciting them sometimes means just sending out a postcard, like under notice and access. Then you've kind of complied with the need to solicit at that level. More importantly, under the universal proxy rule, you have to solicit 67% of the voting power.
Right.
Okay.
To be able to
but
have.
again, that solicitation can be really straightforward and can be really streamlined. Importantly, that leads to a really potentially interesting tactic that activists have started to think about, which is because soliciting is not the act of succeeding. You can commit, like in a notice letter or in whatever, I'm going to solicit 67%. Okay. But you can continue to do that up until like the day of a shareholder meeting.
Okay.
So you could solicit, a few shareholders 3 days before, and then whoop, you get to 67% the day before, and the company doesn't really know what's going on at that point. So because you don't have to like send in the proxies like 5-10 days before, you just show up at the shareholder meeting. You do it electronically. You can sort of commit to doing this and then do it kind of later, which also can kind of put the company in an interesting corner, because if they don't exactly know what's going on, maybe they're a little more inclined to talk to you or settle or something like that. So
it's the activist benefit to delay talking to some shareholders and sort of keeping their conversations, and that helps keep their conversations quiet.
Potentially. Yeah, exactly. Because companies have a huge number of advantages here. In just in general, in any kind of proxy contest or any kind of really corporate governance, they set the schedule for the shareholder meetings. They can communicate in really an unlimited way with shareholders and so forth. So the more that an activist is able to kind of do stuff without the company kind of knowing, is kind of their advantage. It sounds kind of underhanded, but it's really just a response to the way companies sometimes do this. And I'm all for a more constructive set of relationships, and at many companies that's evolving. But there's plenty of activist situations. I'm involved in some now where it doesn't work. It's not that friendly. Yeah. And so you need to do this kind of stuff.
Yeah, actually, I remember there was one called, I think it was Take Two Interactive, and it was before advanced notice bylaws were as common. I think they actually did very quietly solicit shareholders taking advantage of exceptions in the proxy disclosure rules.
Right. There's a 10 or fewer exception.
Yeah, exactly. And also, if
Take
you're not,
Two
I
did
don't
that.
think they apply if you're not soliciting a proxy. That is, if you're soliciting people to go to the shareholder meeting by themselves and vote, not to get their proxy. None
Right.
of this. You don't have to
Oh,
disclose
absolutely. If
anything.
you're just saying, "Are you going to attend the meeting?"
Yeah. So
please attend the meeting.
They you can even tell them to go to the meeting and vote because you're not soliciting their proxy.
Right,
And
exactly.
so without an advance notice bylaw, I think in that case they were able to pretty much run a proxy contest without management knowing about it until the very last.
All right, and Take Two, and they also took advantage of this, what's called this 10 or fewer exemption.
Yeah, the rule.
So if you're soliciting 10 or fewer shareholders, and what we mean by a shareholder sometimes
This
can
is
be a
a
little
little
wonky,
complicated,
but in
yeah.
this case they were able to comply. So they saw that this is years ago.
Yeah.
They solicited like 8 shareholders representing enough shares, and then the soliciting shareholder showed up at the meeting unknown to the company
Yeah.
with enough proxies to prevail.
Yeah.
And won.
Yeah, but now these days, now that everybody has an advance notice bylaw, I don't think you can do that anymore. But it was funny at the time.
Yeah. So this again, it leads to some of these interesting ideas about the minimum solicitation and so forth that activists are kind of thinking about ways to comply, but not necessarily give the company too much of an edge. This also leads to an interesting situation involving proxy advisors. That's the other kind of end of this, is that the ISS and Glass Lewis are possibly in a really kind of a bit of a pickle here, because the act of soliciting is now being, at least in some ways, the act of advising shareholders about how to vote is being deemed to be solicitation, which is really kind of weird.
Yeah.
And this is kind of an artifact of companies, long wanting to regulate the proxy solicitors, not wanting, them to be able to have as much, freedom to, there's debates we've talked about here and elsewhere. And so the SEC expanded, like 2020, expanded the definition of solicitation to cover them because they had actually proposed that the solicit include, I'm reading here, any proxy advice that makes a recommendation as to how to vote.
No, they did. They amended the rule.
Right, exactly. And now that's tied up in litigation now, so that's actually not.
I know.
not
I mean,
happening,
it was it's a really specific thing. So the idea is, and this they wanted, and this comes more from the conservative side, wants to put more regulation on proxy advisors.
Right.
So
Exactly.
remember, if you are a solicitation, you come under the proxy rules. So that's what they did. They amended the definition of solicitation to make sure that it captured proxy advice. And then if you are soliciting, you have to you are subject to all these disclosure obligations unless you're subject to an exemption. So basically by saying proxy advice is a solicitation, that meant that proxy advisors would have to disclose all this stuff, including their advice. And you can't sell your advice if you're disclosing it publicly.
If you're going to
So it would
disclose it
destroy
publicly.
right. So basically they were saying, if you want to not have to disclose things, you're going to have to comply with our rules for how you go about giving your advice. And they had these rules that the proxy solicitors the proxy advisors did not want to comply with.
Right.
So then the Biden administration repealed most, but not all, of those rules. And and ISS sued, saying, well, we're not solicitation at all. We should never have been defined as solicitation. They won, but it's on appeal.
Right, it's not right, exactly. So this is still tied up, and there's a chance it'll happen, which would be really, really bad news for the proxy advisors.
I mean,
for them to.
I don't think they have a lot of friends in this SEC.
No, correct. But again, I think the litigation has to work out. It's not like they're just appealing. It's not
Right.
this
Well, they have
rulemaking
to. There are a couple different litigation going on about those rules, but the main thing is it's in the D.C. Circuit as to whether or not you can even call proxy advice solicitation. The argument from the proxy advisors is, if you come to me and ask me for what I think and pay me, then I'm not soliciting. That's not what solicit was meant to
exactly,
interpret.
and I think that's a strong argument. I mean, you've heard me say this before. I'm a strong supporter overall of the proxy value. I think they provide a valuable service, and it's consulting.
Yeah.
They got problems that I've complained about, but whether they're soliciting proxies ain't one of them.
Yeah, and that's basically, and obviously, one court bought it. We'll see if that plays out.
We'll see if the
on
next
the
one does. Anyway, cool. Well, that's kind of what I had in mind about this soliciting. This is good. I'm glad I got a little input here from you about how to interpret the statute and the or the reg, and how it affects the proxy solicitors. I think we can kind of leave it right there. How's that sound? All right, cool. Let's wrap up. And it's been terrific this time talking with you. We'll be back again very soon. We'll continue with the subject. We'll have to revisit this Target case in the next few months once there's some developments. How's that?
Yeah.
Okay. All right. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is the Michael M. Fleischman Professor in Business Law and Entrepreneurship at Tulane Law School and an affiliate of Tulane's Murphy Institute. You can find Mike at theactivistinvestor.com and Ann at law.tulane.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening. We will talk again soon.